that brings a case under this action is subject to attorney's fees. It's black and white. It's the only statute that existed like this. Whether it's criminal or civil, it does not make a distinction within the confines of the statute. And the state's response was basically that it shouldn't apply because the Hyde Amendment was a federal case and this is not a federal case. We included the Hyde Amendment just to highlight our argument. We believe that we're entitled to fees because of the protracted litigation that they put Mr. Rosner through. He's had to fight his way from 2017 to the very moment I'm standing here right now under a case they never should have brought in the first place. They brought the case, not us. We just defended the case. We're the prevailing party under 517. Now, naturally, this 812 action that I'm arguing now isn't part of that whole case. Our case is strictly directed at this one section. Mr. Vanderdeesen wrote in its response that the section doesn't apply. I have no idea what he's talking about. He's charged under 517. It's in the 517 statute. It's literally the last page of the chapter when it comes to whether or not he's entitled to attorney's fees. It's practically black and white. I don't understand how the state can say that they're not responsible for this. It was a brought the charges and they're the prevailing party. Simple as that, Judge.
Thank you, sir. Steve?
Judge, the defense is confusing chapter with section when it interprets that they're relying upon. Section 211 of chapter 517 is a rescission section, and it is meant to address actions, civil actions between parties for rescission of a purchase. It's not meant to address criminal matters, and it specifically says in that section, it doesn't say action under this chapter. He's not being charged or pursued for a rescission action. He was pursued for criminal action. So that section does not apply to this case. And I will then rely on the remainder of my written response, which explains why defendants in criminal actions in Florida are not entitled.
Just briefly respond. I don't know what he's talking about. There is nothing within the confines of the statute that even refers to the rescission action. I've read it 3 times. Plain language. And we're the
Well, good morning to you, Judge. Yes. It's good. I don't know if we want to stay longer because it tends to get colder.
I was going to say good morning to you, and I said good morning to everybody who's here when it's 9 o'clock.
I was here way before 9 o'clock. And
I was told.
And I was I'm surprised you're still talking to me, period.
Mr. Benjamin said you were around, Councilman. He said you were here.
He was covering for me, Judge.
Ms. Bradley, you all set? Yes, sir. All right, Ms. Reagan, good morning. All right, this is on State of Florida versus Demons.
Stu Adelstein, Reagan Liberty, and Jamell Demons on behalf of Mr. Hammond, who is present.
Good morning.
Judge, couple things. You did receive your trial order that you issued back in July of 28, specifying all motions have to be filed 10 days prior to the trial date. I know that I have filed, in addition to the motion for following hearing, some other motions. There are some more coming from the court. I did, pursuant to your order, you indicated that we have, or you have ordered that all trial exhibits.
What's the standard order? And I asked the parties to exchange exhibits, let everybody know what they are. But in this case, it's a little different. I mean, is there some new exhibits that are out?
I don't know.
No, Your Honor, and actually, in fact, the defense counsel, Mr. Benjamin, has asked for copies of all of the USBs that were introduced in the last trial, so I've been working on those. I finished those this morning, with the exception of the defendant's cell phone, because it contains child porn. I am not allowed to copy and disseminate it.
So,
What about the rest of it?
Yeah.
I mean, I don't think the whole phone is literally all child porn. She introduced thousands, literally thousands of parts of the phone that were child porn. And for the state to say, I'm not turning it over in its entirety because there is some child porn, I think is I don't want to say disingenuous, but it doesn't live up to their responsibilities under the discovery. It's just ridiculous. It takes 5 minutes. So I didn't know it at all, because there's a minute amount of child porn in the entire phone that she is basically used as a feature of her prosecution. That's not right.
So instead, Your Honor, what I had done was I took all of the chat reports for those videos that were introduced in the last trial and copied them. It's my counsel to let me finish. So those are the 30 USBs, leaving them there for the defense counsel whenever they want.
These are ours.
Yes.
So Judge, that was part and parcel of my first motion to compel discovery. Thank you, Mr. Adley, for coming out today. We had one 2 weeks ago. There is one other issue, which would have been part of my motion. I had asked her for a plethora of other documents, but she said she's not in possession of, which is necessary for our self-mapping expert. We can get a response on that, because I did ask for this information almost 3 weeks ago. If she cannot provide it, I would ask that we be allowed to redepose Agent Collins, because he's the one who would have these items in his possession. We are, again, as Mr. Adelson said, under a trial order, so time is running out, and we need the documents, or we need to depose Mr. Collins, so we could ask about this document.
I thought this was going to be easy, we just tried once already.
It's going to be more complicated, because I will advise the court that we have taken somewhat of a new approach to certain issues. And that's why you will get some additional motion timely pursuant to your order. I did also file my notice of unavailability, and the court was kind enough to push the court to file a commencement from October 2nd to the 9th because of rather birthday trip. But I wanted to just inform the court of the days in the state of the things that I was going to be unveiling.
But this is all prior to...
Prior to,
commencement.
yes. And I filed that on the 29th. I've also sent and not received a response from the state asking when we can view all trial exhibits pursuant to the court. I'm waiting for that response so that we can organize a mutually convenient date because we all have different schedules prior to this trial. I did file a motion to compel Brady material dealing with primarily an investigation based upon a complaint against Detective Moret. I did receive a response that I don't believe is complete. And I would ask the court to sometime look at the material on that. I believe there is a statement of a witness observing improper conduct.
Handing over to defense a copy of the certified letter that was sent to the complaint leader and his mother, saying that there is no complaint that was substantially unfounded.
Well, we are entitled to that investigation since it's closed. I will tell the court that I believe there was a witness to this incident, which was an assistant state attorney concerning improper conduct of Detective Moretti against a potential witness in this case. And I plan on issuing a subpoena for her deposition. Just want to put everybody on notice.
Are you going to be ready for trial?
Yes, absolutely.
I didn't know if this was all we could do.
No. We're doing this with every intent of starting October 9th, as the court indicated. We're just doing this because of, and I'm alerting the court of this, because when I filed my motion for bond hearing, which was on August 15th, the first available time was today, according to Ms. Bradley's schedule. And I need to comment about it. I filed this motion for Arthur hearing, bond hearing, on the 23rd day of August. Oh, no, I take that. I think it was the 15th day of August. I got this response to my motion late Wednesday evening, which I think is somewhat unprofessional to wait a day and a half, less than a day, or less than 2 days, to respond to a motion that was filed a month ago. Now, I'm not asking for a continuance, but I want to draw the court's attention that this is really, in my humble opinion, very unprofessional to wait less than 48 hours on a motion that was filed a month ago. I don't appreciate it. I don't think it's fair at all. And that's why I'm now asking to review all her exhibits, because apparently she's a very busy person regardless of our schedules. We should jump whenever she's ready to go.
We have a problem. So, you know, and that is that Monday I started a trial with State of Florida versus Boston. It's a case like yours. There was a plea hearing and it has to be retried. There's time periods of time. It's set to go start on Monday. It's going to take approximately 2 weeks. Ms. Bradley is the prosecutor. She knew me with me most of the time. That's an issue. I'm trying to let you know this. I then the following week I have a case set in Dade County that through an executive assignment, we'll be down in Dade County for that October 2nd. I won't even be here in the courthouse. They require me to go to Dade County. They wouldn't agree to try it up here. So I won't even be in the building, all right? So, that week, I'll basically out of pocket, so to speak. You won't be able to get me unless we can do something on that Zoom or something like that. I don't know how that would work in this anyway, but there's issues even with Dade County. I don't know what availability I have. I don't know what they're going to provide me now. So I'm just telling you, there's issues that are coming up. But the time that I have, it's short hearings. I'll get you in beforehand, next week or the week after. But it's got to be, I can't be.
Understood that, but as far as Ms. Bradley being here, she has co-counsel, and her office has some approximately 200 lawyers. So, I mean, with all due respect, she has co-counsel that has been with her throughout the trial and the pretrial motion. So I'm just advising.
I'm just telling you on the motions, that third week before the October 2nd, I'm not going to be in the building.
Fair enough. I thought you were celebrating my birthday.
With regards to Mr. Bostic's case, I don't anticipate it finishing by the end of September, because we didn't realize that Monday we were off, and there's 2 additional witnesses that are calling this time that we did not call last time. So, I'm scheduling, I know.
On the motion for bond, we're in agreement on one issue, that the burden to deny bond is higher than a reasonable doubt, proof evident presumption rate. And that's what her cases basically say. Certainly, since the jury could not reach a verdict, there was a reasonable doubt by whether it be 1 or 10 or 9 jurors on the charges. Therefore, based upon the evidence Your Honor heard, they certainly cannot carry the burden of proof evident presumption rate, which every case that she attached to her motion says is the proper burden. I would also bring the court's attention to, she wants the court to look at certain exhibits and testimony. And you've heard all the testimony, but she included witnesses that are either lost, unavailable, or she cannot find. And certainly the court should not consider any of those witnesses, specifically Mariah Hamilton, Nikita Bagley, the Christopher Williams construction report, he testified. You heard his testimony. And all the other exhibits that Your Honor heard. So I think it's a really simple issue. The state cannot carry its burden of proof evident presumption rate. Therefore, the court has the right to set a bond. Melly was born in Florida, raised in Florida, has no passport. His mother is here, his family is here, as they have been here almost every day of the trial, as the court knows. And certainly we can structure a bond, including GPS and house arrest if necessary, which is the most restrictive. But at least give him an opportunity for a bond, because he is presumed innocent. And there's no way in heck the state, based upon the lack of a verdict, they can carry their burden of proof evident presumption rate.
Judge, we have one case, if I could just jump in. It's a very short one, 2 pages. I'm handing the state a copy. And it's your argument approach. It's kind of short. And it's a Supreme Court of Florida case decided, believe it or not, in 1945. And it's called State versus Freer. It's at 20 Southern 2nd, 481. The Supreme Court said that, and there's not much case law dealing with a hung jury issue as to proof evident presumption rate vis-a-vis. But this case specifically says it is an added factor and that the court on a bond hearing, an Arthur hearing, needs to take into consideration, and this upheld the fact that that court let a guy out on bond, a woman out on bond, after there was a hung jury that they couldn't decide beyond a reasonable doubt as evidence to show that there is no proof evident presumption rate. That case is black letter law since 1945. It's still law today. And we asked Your Honor, who heard, this court heard every bit of evidence, and the state, I'm sure, didn't hold back other evidence that they had and didn't present to the jury to be able to prove beyond the exclusion of a reasonable doubt. They shot everything they had, and that jury was hung and could not find that there was beyond a reasonable doubt evidence. That's proof that they can't meet the higher burden of proof evident presumption rate. And we'd ask Your Honor to consider that. We have a case where there's a co-defendant who's been on bond in perfect compliance with regulations all this time. Mr. Demons deserves to be out on bond too, with this added piece of evidence that shows that proof evident presumption rate status hasn't been met.
Thank you. Is there anything else?
On that issue,
On Bob's findings. I did receive I haven't looked at it yet. It just came into my office. A file. I haven't looked at it. I assume this is just exhibits that were in the trial.
In addition, Your Honor, all of these information was provided to defense counsel back in 2019 when the initial discovery exhibit was filed. So none of this is new information to defense counsel. In terms of the statements and things of witnesses that did not testify, defense counsel is making a suggestion they are unavailable. Statements submitted, those are still allowed to be relied upon. But the problem that defense counsel has is they are arguing the wrong judge. It is not what a juror, specifically one because they fanned and lied during jury selection on multiple occasions and then hung the jury for one woman, had any other opinion as to the case. It is Your Honor's job to sit and determine if it is proof evident. Great.
Judge, I have to object. There's no evidence as to...
Okay, I did not...
Judge, I have to object. We have to make a record on a first-degree murder case.
You're going to have to.
Oh, well, I just want to reserve, I object to her characterizing evidence that's not what we were.
So, Your Honor, it is your responsibility to make that determination. So, Your Honor, they will submit that there is proof evident presumption rate based on not only the evidence that was presented, but as well as the additional statements of witnesses that defense counsel suggests are unavailable for the purposes of trial. In addition, Your Honor, as this is a hearing for bond, it would be appropriate and pursuant to the Florida Constitution for the victims' families and members of the next of kin to be able to address, Your Honor, as to their feelings. My understanding is that Ms. Leandra Phillips is present on Zoom and would be addressing the court in that way. Also present are counsel for Ms. Janet Thompson, mother of Mr. Williams.
Judge, I know that the Supreme Court has came down and does now allow for appearances to happen telephonically or over Zoom. However, that order also requires the state to file a motion 20 days before the hearing, giving defense counsel the opportunity to object or to agree to the appearances over Zoom. When we were scheduling this through your office, we were given 2 days and we were pushed back almost a month for them to appear here. So for them to now appear over Zoom, when we pushed this back for the victim's family to be physically present, we could have had this for a month ago and they could have been over Zoom. It was set today for them to be physically here, and there is no motion filed by the state attorney's office, and they should not be allowed to testify telephonic or over Zoom without the proper motion being filed by the state attorney.
And so, Your Honor, in terms of next wishes to set it out 20 days to object on that, I'm perfectly fine with, we can find another time for that. With regards to the date, this was set because of my trial schedule, and that's my availability.
Thank you. In any event, you don't anticipate the family of these the alleged victims that testify. They just want to share what their thoughts are, correct?
Correct.
Thank you. Judge, they want to say something more than that.
Leandra? She might be with Ashley, that is her sister. And then I know Mr. Phillips, who is her counsel, was a hearing via Zoom as well.
I don't know who Mr. Phillips is on this.
He signed the notice of appearance on behalf of...
Is there a Mr. Phillips there? I don't see any Mr. Phillips. And what's the lady's name?
Leandra?
Is there a Leandra there? They're not responding.
Garth, I have just a moment to get in touch with them. I've been emailing back and forth with them.
Give me a second. Go ahead and make your phone call. We're recessed. Kyle, cool, collected.
How you doing?
I'm well. How are you? Things change. They become a member of the family.
I'll leave it at that. So we have a Yes.
Right.
Absolutely.
That should be the logging on that. Leandra, could you go ahead and turn your camera on and unmute?
Yes, I'm here.
So Leandra, can we go back on the record on it?
Yes, let's get back to where the state of Florida versus Demons present is the defendant, his counsel, the assistant state attorney. The counsel, you wanted to call someone not as a witness, not to testify, but just to share her feelings, is that right?
Yes, sir, it's her input on bond and the statute.
And what is your name, ma'am?
My name is Leandra Phillips.
Can you spell your name for the court reporter, please?
Leandra Phillips.
Spell it.
Leondra, Leandra Phillips, Phillips.
Thank you, ma'am.
Ms. Phillips, you are the mother of Christopher Thomas?
Yes, ma'am.
And what are your thoughts or opinion on Jamell Demons receiving a bond in the homicide of your son?
I don't think he should receive a bond, but I do know that he's innocent until proven guilty. But these are some serious accusations against him. So, and I understand he has money and don't want anything, nothing to happen to me or my family. So I don't think that he should be granted a bond at all.
Thank you, Ms. Phillips.
Thank you. Anything else, Counsel?
No. State would stand upon the written response as well as incorporating into that the evidence that was presented at trial.
I have, again, I would object to the court even considering the statements of people that even the state has no idea where they are. We have, as I brought up several times, prior to the trial, during the trial, we have attempted to subpoena those people for deposition numerous times, most of them. There's a material witness bond as we speak on Mariah Hamilton. They don't know where she is. I moved to exclude many of those.
That's Mr. Demons, I don't know if the president or former girlfriend.
Yes.
Mother's name.
who testified, and as the court knows, precluded her statement. And now they want you to consider something that the court has already ruled as inadmissible. In addition to that, they claim they haven't given us certain copies of things because it contained child pornography. They have violated their own rule because they gave us and sent to our investigator exactly what they're saying they can't give us now, previously.
So you already got it, so why are you asking for it again?
Well, we were asking for the exhibits because they did not include everything that was on, that they extracted from the phone.
But you already have it?
We have it in a different format. As the court remembers, they introduced about 20 to 30.
I know that a lot of text messages, photographs, things like that.
But they introduced them through USB,
Yes.
numerous different ones. What we wanted, because I assume they will use the same ones, to give us copies of the portions that were introduced at trial so that we could file the appropriate motion in limine concerning some, if not all, of those exhibits.
And I think what she handed us, although we haven't looked at it, we're assuming that the bag full of jump drives that we were just handed is all of those things that she introduced in the first trial. Although the state told me on a phone call that she is free to change or add to that or do whatever she wants to try to introduce evidence in the second trial, but at least this gives us what was introduced as a starting point so we can address it in the motion in limine. So now we have it, I think, although I haven't looked at it yet.
And again, according to your pretrial order, we are to view all trial exhibits prior to trial, and I sent an email to Ms. Bradley.
Sure, should I coordinate something with somebody from our office? Sure.
Yes.
So there was also a motion that was filed for DNA discovery to expedite that and file a public records request with the crime lab. They do require a court order, otherwise it will be redacted.
So, may I respond to that? I do have the court order prepared, and I apologize, I ended up with a sick child, so I didn't even email the judge the motion yesterday. I'm glad you read it. I do, and I can send over this afternoon to you, under the certain statutes, and I apologize, I can't remember off the top of my head. There are two statutes that we would be moving under that, because they hold it, which I'm sure you're aware of, we can get around the Chapter 119 issues, so I'll send you over the order, you review it, like it, I think we can get those documents there. I would ask that 7 days, would that be amenable to the state?
It'll probably take upwards of 20 to 30, that's just based on prior experience with how long it takes for the crime lab to get everything together. You're looking at,
So I'm only looking for the files, so Judge, so if you're aware.
No.
So I filed a motion yesterday. While we were in trial last time, I believe it was 5/25, report was done. We ended up getting that discovery on.
Motion to strike.
Yes, Judge.
Okay, so I didn't have it, I saw it. I didn't realize it was separate. Go ahead.
It wasn't, I'm sorry, she's reading it, so it's my fault. But yeah, I have the order that she needs. If it's 20 to 30 days, we would also ask if we could depose Kurt Rhodes, specifically only on the testing from, I believe 5-3 was her first test to 6-3. So there was additional testing done while we were in trial.
It's not, he's the DNA analyst.
Yes.
And is he, were you able to depose him initially?
Yes, but not regarding the tests that we were given while we were in trial. So 6/3/2023 was the first time we were ever given a report, and it was the first time throughout the 4 years that our client's DNA was included on anything. So even though we had deposed it before, it was years prior to this additional testing being done. And that's why it's really clear with our motion, everything I want is regarding from from May to June, that particular DNA testing.
And you're saying, representative, that those testing or whatever was done during that period was not the subject of any deposition that you had with Mr. Brooks?
Exactly.
Without objection, Your Honor, and just in terms of the schedule and time.
What I got there?
Yes.
Good, jury.
Oh, you want me to?
I thought I was talking to it.
We don't have everybody up there, so.
Okay, so I'll get the proper order, which Ms. Bradley's talking about with all these statutory and 119 language in it. There was one other issue with regard to my other motion. Granted, part of it, she's handed over to the state's given Mr. Benjamin all of the 31 discs. I did need additional information regarding cell tower mapping. She says the state had told us that it was not in her possession. If it's not in the state's possession, I would ask then the alternative is if we can redepose Brendan Collin about these particular items that I'm looking for, or we give an order that she can give to Mr. Collins and give him 7 days to give us those documents.
So you're going to have specific items listed, there's nothing that's in the state's possession, nothing that's ever been in the state's possession. In fact, they specifically state federal agencies and other funds that are to be done. But if they are now calling their cell phone expert again, we're then back in the situation where the state has to depose their expert. Because if you recall, we had sent out on numerous days, they then canceled it unilaterally, even though I had set it on a weekend to continue this deposition. So there's going to need to be time for that. So I think we need to do a... in terms of for scheduling, I think we need to figure out if we're going to build days in the jury selection to address these issues on that and testimony on that for those purposes.
So I believe we have Fridays open while we're picking a jury. No?
We're going on Mr. Bostic's case by the attorneys who work on every day. We have the 25th is a holiday, and I'm supposed to be down in Dade County on December. So,
Hey, Bridges, it's total.
my goal was
It was 41. Can I have Bernard Gonzalez, please?
I was my
It's just lost
What about during our jury? So we start July 9th, well, here. I'm sorry. October 9th, sorry, Judge. What about those Fridays? Could we use those?
We're ordered to be in session on those Fridays.
So we're going Monday through Friday?
I'm going to start going Monday through Friday. I'd like to get a trial done. I don't want to rush, whatever, if you need something done during that time, we'll figure it out. But I'm trying to go Monday through Friday.
Okay, so if I could just start with the discovery request, and if we could get an order, if Mr. Collins could turn that over to me in 15 days, and then we could figure out if we have to redepose them once I get that, I think that would be the quickest and smartest way to do it.
Yeah, I can't remember what I have on that, and so Mr. Collins, if you recall, is a federal officer because he works for the Federal Bureau of Investigation.
I'm going to let Mr. Benjamin respond to that because there is black letter law. Sorry, Mitch.
Go ahead.
The state puts on evidence, some of which is an officer with another agency. The black letter law is that the state's responsibility is as to discovery, not what's in their file in their desk, but what all of the other agencies that are working on the case have in their file. She's aware of it now, that this is specifically what we want. For her to say, well, I don't have it, you got to get it, I don't think is fair. There's rules under how, when a state seeks a federal agent to testify, what has to be done to get that information. She's well aware of it, and she can get it by picking up the phone and getting it from her witness that she called from the federal agency. So it's under her umbrella of information, not just because it's not sitting in the file in her four walls of her office. So, I mean,
Pursuant to your order, I did file, it should have been an amended defense witness list for the penalty phase. I did not list the addresses as Okay. I did also file a motion for penalty phase evidence for them to comply with. Rest on that motion. I have not received a response yet.
Was this just filed?
It was filed, yes, probably yesterday.
Right.
But I'm trying to comply with Your Honor's order. And I did file a motion for discovery of any investigations of prospective jurors, like the NCIC and driver's license that they have access to about jurors that they run the priors on to share with us, because we do not have that access. I don't think they would object to that, but I did file it in an abundance of caution.
Those are the set current this morning, so I'm trying to respond to those. I'm very
All right, so regarding the FBI agency,
Mr. Collins, Franklin Collins.
The last time we were going to try to make phone calls to him to get him to see if he could be available for come back in. We made arrangements for that, so we have some relationship to him. I know he's a local very first here in this area.
He is, let me check one thing on there, the deletion and nursing. Vacation.
That's fine, so why don't you find out where he's at and what his availability is, and see if he can accomplish what the council is suggesting.
And so then they also have to readdress defense counsel making their expert available, because they concluded the position before it's finished. Then they also have to relist their experts that they had previously, during last trial.
Who's the expert?
Well, one of our experts died after trial, so I'm in the process of getting a
So you
replacement.
haven't found him?
Yeah, so,
I didn't notice he was an expert.
yeah, I was shocked. I was using him on another case and it came up in another, but he passed away probably a week after our trial, so I was a little sad.
So you're working on it?
I'm working on that. I do have the expert for the cell mapping, which I will turn over to her. We can set up definitions for that.
Okay, so you're working on that, same thing with his friends.
So,
Your Honor, allow me a second position with him based on, I want to make sure it's clear on the judging order or anything like that. There hasn't been,
I thought they indicated that they were looking for certain documents and other exhibits for the cell mapping that wasn't done. Or the DNA analysis, the DNA is something that's, they want to repose that witness, because they did ask them certain questions about certain time. And I'll be clear with that.
without objection from the state on that. So, but they never even asked me about doing that by agreement, which I would have been happy to do so. They just haven't. So, and then these other items that they are listing are not in anything from the state has, and my understanding from Mr. Collins, the state hasn't either. And so if anyone wants to set that for a hearing for Mr. Collins, who would come in and talk about the items that they're
What item are they on these motions? Which motion is that?
so it would be my first motion to compel.
So that's not one of the ones that's in front of us.
I filed it like 8/31, which included a list of the state's discovery, which is moved. Basically what it is we want the FBI director's CAPS reports. There was a case out of Pennsylvania. We wanted the Daubert information from that. And there were a few other things. Yes.
All right, so why don't you have a seat?
May I?
Yeah, why don't you have a seat? Let me get, I have a jury out, they brought this, so I have to let me take care of that.
Yes, sir.
Can I say, who's here to this stage? We'll be in recess on Mr. Demons, you can take him down, bring up
I've never been affected. I'll make time. All right, let me know. Oh, you mean this
I'm available. I just don't know the jury selection. Judge, for our trial,
We're going to work on the record. We need to be on the record, or we're
Just scheduling right now.
We just scheduling?
Yeah.
for our trial, we're going to work 5 days a week.
That's what I hope to. Now, on a Friday, some Friday, they got to start a little later. I do have something, the judge reminded me, I got a sentencing on a case next Friday. When is it, next Friday?
It's next week.
Next week Friday, I might have another one.
But when we start on October 9th,
I want to
we're going to do 5 days a week.
That's what I'm hoping to do as much as we can. And now, if you have something in the middle of the trial, you schedule something, we'll do our best to accommodate that, obviously.
Well, but I've been scheduling everything on those Fridays, which is my only concern. I don't have to cancel all of those.
What are you talking about?
Every single other case, depo, status hearings, argument hearings, everything has been set on those Fridays. Because that was our schedule before. So for now, if I'll cancel them, I'll move them. But just so that I know, we don't want to October and November.
So I also have another murder case on the West Coast, and to get after that trial docket, I had sat with my other 3 co-counsel, and we had scheduled depots for almost every other Friday up until January. If the court's telling us now, I guess I could bring it to their attention, and we could figure some, I don't know.
So you're telling me you both made other arrangements based on the schedule we had last?
Yes. I apologize if I was...
No apologies necessary. All right, we'll just leave it the way it was. We'll go Monday through Thursday.
Monday through Wednesday, you said? Thursday.
She's already grumpy.
Judge, do you want to address the holiday periods, in which days you are going to work or you're not? Christine, do you want to know that for your schedule?
We open when the courthouse is open, we'll be here. You just work it out. The days that you want to cancel for whatever reason.
Okay.
Okay, we'll talk.
We'll do that.
Yeah.
Just go off the record, just schedule.
On Friday.
Raven, you want to come here? What days did you need off for your child?
So what are concerned that they're taking which weeks? What days do they?
Here's
23rd, 24th.
Okay, here's one.
Some saying if schools out on the 20th, schools, the
If I slow down, I get tired. I work on some. You got cold? It's horse. Did you order the food? I can order it. That's right. Oh, I see. But how many people are ordering? It's 5 or 6. Okay. Try and get it. What lady? One lady. That's good. Oh, it's all Willie. Last name's Willie. That's what she cut the meat to. She cut the meat the first time. He said it twice. He said that yesterday. Well, not to them, but he did say he said
And you got it.
I don't have enough here. That's No. He's going after him. Yes. It was a freezing. Almost as good as Bell's. Carrot cuts a couple of gallons or so. So skill.
Oh, the phone's on. Like, who's in my bed? All right, bye.
But I'll come back to check on my phone. I'll come back to check on my
As long as you don't really know what exists.
I like that. It's always like, hey, see this guy? I said, feel free to mess with him. You want me to punch him? And I go, oh, I tell you to mess with him, and your first idea is to assault a college student? He goes, no, please don't punch him. I was joking. Okay. Felt like silver. Punch him in the head. Get your first
Yes. Sorry. I'm running on Hughes.
It's all mine. I work less.
West State here. I think their house closes west.
No. There has to be somebody here always. From 11 a.m. or 11 p.m. to 7 a.m. That was this year.
At least you have video.
I need to see this. I was like, this has to do with it. Oh, yeah.
I remember sitting here now home for child. Can you differentiate between facts and but I'm using her
I immediately saw it go.
Vortex, like when she comes up school. This house to watch.
But that's that.
You got it.
She sent me this picture.
Literally talk the whole thing about
This is under investigation and
You just want that. She found that.
There's not too because of this trial, my grandma's only one. It's supposed to be 10, but I guess that's in Denver for days or 9.
So you're getting rid of the other one, right? You're getting rid of the other one. Oh, I remember that. I don't remember what it was.
Well, you know, I got stuck in Denver as like outside of the whole town because I
Wouldn't say up to have the
don't ever like Denver.
Quiet, please. Quiet, please. All right. All that for this delay. Represent the evidence of the defendant, Deputy's counsel, the assistant state attorneys. So let's just do a recap. You have a motion for Arthur hearing.
Yes.
Counsel gave me a binder, and you provided me with a case statement in the rear. I'll take a look at that, so I'll make a defer ruling on that. And then we talked about a motion to help discovery regarding DNA analysis, and you wanted to be able to take the deposition for submissions between May 1st and June 30th, and that's fine. Just draft an order regarding that and take care of that, so you'll do the order to show to the state. I got your defense witness list. What's the issue with this motion for discovery of prospective jurors' investigations? State name, objection, I haven't seen this.
Judge Wickermark said NCIC I cannot turn over, and generally we wouldn't run an NCIC on any juror. They would have access to the exact same things that we're doing, which is different clerk's office. Same way that we've done.
So you're saying this is just your trial work product?
Well, yes, and so it'd be the same. There's no special state-only exception. I do not have access to the data database. I don't have access to NCIC. That is something that would have to be requested from my office, and that's not something we would do on each individual juror. And also the NCIC cannot be provided.
So you're saying you don't, this thing about background and investigation of prospective jurors before and during jury selection process, your, previous criminal histories, driver's license checks, things like that?
They're not run through NCIC or on data. No, that is not a permissible process.
But you do have access to criminal histories.
I have access to the clerk's office, just as defense counsel does in certain.
So Judge, if you recall during the last year's election, a couple of jurors had testified about family members, and the state attorney was able to find these family members and their convictions and what had happened in cases going back to 20, 30 years. And that's all we're asking is that we are not left out in the dark and we're provided the same information that they have access to.
Thank you. Counsel's telling me you have the same access. You're saying that's not the case?
I don't believe we have the ability, and I'm just going to use the example, there was a young lady testifying about a murder that occurred with her uncles. They were able to find the case almost 30 years prior, find the name of the uncle, find the disposition of it. No, we don't.
Refresh my recollection, this was done during jury selection?
Yes.
So it was
Several
disclosed to
times, actually.
defense, and again, so it was disclosed to defense, and in terms of those, that was from the clerk's office. That's the exact same system defense has access to. Clerk's office does not show that. Sorry.
So if you get information, you run something during the trial, i.e. on prospective juror, as far as through the clerk's office, whatever information you get, what type of information would it be? In that case, it was some conviction. So you share that with or you make a statement in the court.
That's what we did last time. They were made aware of the same information that we had.
So what's wrong with
The NCIG is pursuant to CJIS rules, which is Criminal Justice Information Security, and not be provided on behalf. But like I said earlier, that I was not prepared to argue, that was not set for a motion.
I didn't set it for a motion hearing because I was waiting for quite candidly a response saying whenever investigation would run on prospective jury, they would share it with us. That's basically all we're asking. We don't have that access to certain information. We would have never found out about that one juror that Ms. Liberty just mentioned. Obviously, they had a quicker way of doing it.
That was because she disclosed it, and she mentioned that her family member had been a victim. So we asked her for the name, she provided it, and that's how we were able to look it up.
I don't remember the specifics of it. I do remember it was done, and I also remember it was shared. I think counsel was asking the same thing we have, and we have something to share.
The issue I take is with the wording of the motion, because the NCIC is not able to be disseminated or shared or copied in any shape or form, and they don't have access to data.
Do you use NCIC jury selection?
No.
Fair enough. Use the driver's license database?
No, that's
Okay,
I
no
have
problem.
access to it myself.
No problem.
In short order, just say you can't use the Dave is not being used, CIC is not being used, but whatever is being used, if either side finds it, they agree to share it with the other side.
Judge, may I inquire, and I know you had told us the last trial that you don't do it, but the jury questionnaires, that
Just so you understand, that's probably what I like the jury questions. I use them when I was a civil all the time, and I think it helped out the attorneys. What we found out in some of these higher profile cases, because usually is here, jurors don't want their names being out there, and it came happening one of the trials that we did. One of the jurors was like foreman, decided she wanted to foreman anymore. The jury selection, she was afraid of her name. We got messages from the jurors that they don't want their names out there. Right after the trial, they come in and they use me to those. They want to see who's on the jury list. It happened. I was advised happened. One of the cases we tried here where we met the jurors at their house before the jury got home. And so what we're trying to do is basically let the jurors be free from anyone being contacted and things like that. So there's no issue in serving. And that's all. They don't want their, for the most part, I found out jurors that don't mind being contacted, they're contacted, usually and things like that. The ones that don't want to be contacted, they're still contacted. And so the point is to protect their privacy. I don't really because anything that I do, if I have it, the clerk's oftentimes is there to make it available to the NBC.
I just have a question. I thought, though, that even in this case, Your Honor sealed the names.
I did.
And so that procedure,
I don't know that that's going to work.
why wouldn't it? That's my question. Is it?
If they ask for a hearing and they want to go through a hearing and they want the information, I don't know if it's going to prevail or not. And I don't want to, I just want to preserve the privacy of the jury. You can ask whatever question you want. I don't have any issue about, the question. In fact, as Counsel Noble pass out a questionnaire, it's the one in the back of the book. It's not any significant, but it should give you a little background. And you ask whatever question you want. It all has to do with privacy of the jury. Because we
then just one more housekeeping issue, and I'll leave you alone for the day. But because we have the cameras on there, the assertion that my client had child pornography on his phone, so those pictures of his girlfriend, I don't want this to be misconstrued as if my client actually has children and pornography on his phone, his pictures of his girlfriend. So we just maybe state that a little differently since the media is reporting and it keeps coming out child pornography.
Thank you. Obviously, I don't know what's on the phone. I've seen those pictures. There should be. Judge, let's just clear, not just pictures.
Yes, please.
Can we go back to the jury questionnaire? If we just had them number, like assign each juror a number.
Why can't you just ask the jurors a question?
We can, but I think it would speed things up. That's just my suggestion.
I do like the idea of referring to the jurors by numbers as opposed to names, because I think that furthers your honor order to keep their identity sealed if that is pursued again in the next trial. Because otherwise, in the transcript for the jury selection, we're saying their names thousands of times. So I think that might be a good idea to pursue. So I'll discuss that with the counsel and see if we can motion or
I'm not trying to beat a dead horse, but if they're numbered, the only reason that we feel jury questionnaires may be appropriate if we can ensure the privacy issue is that it would streamline the jury selection process. We could review that stuff in the evenings. We don't have to go through the questioning during court because we'll have the information before us, and it just may streamline and speed it up. But that's the only reason why.
The other thing I noticed about juror questionnaires is that if there was somebody that, let's say I thought was based upon something that was said, on the questionnaire, there would be an issue with the juror still. Jurors and attorneys don't typically want to excuse the jury based on something in the questionnaire. They still want to question the juror about it. They want to go through it. So you never seem to attain the goal of pulling the process down. To me, it just seemed like it was more information than, well, even after the question, they go back to the juror, something was said in the jury, and that's what it is. I'd just rather have you do it out the juror questionnaire, ask whatever questions you want. And it's all issues I think you make copy, how to be done. It's a whole procedure. You say you want time to look at them overnight, things like that. I agree with all those things. I understand it, and most tobacco cases, they do that at every case. They have 50, 60 questions on their questionnaire. You get all kinds of information, and it works, and they excuse jurors without there's no legal discussion about the case. That hasn't been my experience.
Also on jury selection, I assume you're going to follow a similar procedure. First talk about the scheduling.
Is that right?
Is that correct?
Is that all right?
Yes.
That's the way I like it.
Yes, because there's no sense in questioning them if they're not available. So we would be asking them to talk. And we're working on the schedule as
So initially, the attorney would be asking of doing anything, or
correct.
Just be present. I'll go through, find out who's available, and see the time frame, and that type of thing.
And after Thanksgiving, you can wait for
So tell me, when you talk about the schedule, that's what
We've been
Yes.
going back and forth on it, but I believe it took us 14 days last time to get the jury of the various sessions. Pre-qualifying, groups A, B, and then combining for all of the different appellate review. I agree with administrators on that. So we're looking at, due to the Fridays, that if we start on the 9th, so that's approximately November 2nd, that we'd be looking at jury selection. That's assuming we don't have any additional orders that have to be struck for pre-trial, publicity issues, things like that.
you start on the 9th, you're saying it's going to take you to when?
We're saying till November 2nd before we could possibly seek a jury name.
And why is that?
That's my optimistic estimate, but council seems to think it would take longer.
Why is that? What days?
That would be the 9th through the 12th, the 16th through the 19th. That would be for the time qualifying. And then if your honor start questioning as to the individual and how many are we going to try to get. The courtroom currently about 60 in here.
We'll talk to you about that in a minute.
Yes. So we had to kind of have an idea of the numbers. How many jurors are we looking to get to with a group 1, a group 2 to go through general or death voir dire? First would be the state's preference. And I know last time due to the fluctuation in the law, we held off and discussed that after. So we kind of did address some of those procedural and scheduling issues.
So what do you think regarding board hour? Who's going to handle board hours?
For the regular block hire, Mr. Benjamin, the death issues.
Which one do you want to do first?
General, because again, there are no jury instructions per se ratified by the court, and hopefully by then it should be anticipated to be formal jury instructions.
Steve, you all right with you? Any objection?
Yeah, I believe there were ones that were accommodated. I can double check. I know Judge Fine has done a couple of death penalty cases since the change on that, so I would prefer.
I'll show you what I have.
To my knowledge, they've been proposed but not adopted. Could be, that's my understanding, that they have not been adopted. So my preference would be to do general and give the court, the Supreme Court, as much time as possible to adopt
What we want to get involved in the jury instruction.
or the committee, whatever. I know they sent out proposed ones and they asked for suggestions. I still don't think the committee has adopted formal jury instructions to my knowledge on that.
Well, there's instruction in the book that I report out. It's the same, basically the same thing, it's been updated, tweaked a little bit. But it's the same one I used before. I just send it to you, take a look at it, you don't like it, you don't like it. You tell me what this, you don't like about it. It's the same thing I used before.
But we'd still ask for general.
All states have no issue with it.
I think the general death qualification first, the with questions, is more efficient. I think we talked about that last time. So I certainly want to do it that way, and your honors are welcome to do that.
I don't have the information one way or the other. This is your guys' trial, we're agreed to. Council says he wants to do that one first. I want to do that any objection.
We requested to do the death qualification first, and then general qualification.
So state objection. So we put the it doesn't matter.
Well, that's okay, because I'll call heads and Jamie will call tails. And Raven will call.
All right, so let me work on you think about that.
Yes, sir.
And what about the court?
Last time we brought in 50 at a time. Except 25 here and 25 in the back. And giving room for various candidates.
So what happened with my, you still got family?
Yes. You can see him right now, just for this.
So I don't know if I can.
Understood.
But it's an issue about getting bigger polo. Talk to Judge Polo. I know certain dates. They will not be able to speak. I think that polo. Yours down. The Jordan is next to me, right? Yes. So I think that'll be. But it's bigger.
It's what?
I would. Let's see. Oh, darn. So, again, I don't know what you want to do, if that would speed the process up or not, but if we just do the, at least, the night question, if we do the groups, find out availability, we can get more people in at one time. I don't know how many years you get these days. Well aware.
So 200 a day is the goal on each to go through for time qualifying. 200 a day. Do you have more instruction on?
This initial scheduling question.
Scheduling question on that.
There's hardships you can't do that explained in time.
And so that was, we went through 800 jurors that way last time. So that would be 4 days. I would anticipate it a little bit longer due to additional pre-trial listening. So I would say we should need 6 days for those. More or less.
I think because of the holidays, it will take longer. And
I know you're wrong.
I hope I'm wrong too. I also would ask the court that when you mention sequestration, I don't think a lot of them totally understand what that really means. So that you define that they will be locked up in a hotel, not necessarily in those words, but, and precluded from seeing. Yes, whenever they go out. I think that because of the holiday season, I think that's going to pose additional.
Will we go, Monday through Thursday, we're starting on the 9th, right? So the first 2 weeks are just for hardships. And assuming that we get enough to start with the attorneys, started on the 23rd, right?
We're going to do the same 2 groups, a group A, a group B, and then combine.
In the next phase.
So, I mean, let's say we go through, because it's all done by the court, they keep track of the order, so to speak, that's on that list. And so we go through and whoever's able to stay, Travis will get us a new list from the clerk, and with those names on there, so how many names do you want on that are able to stay before we start with the attorney's questions? What's the number we're looking at?
Approximately 100.
Okay, so we'll go for 150. Write that down. 150, and so whenever we get that magic number, so to speak, and then we can prepare, not prepare, but start on the questions by the state and by the defense. And I don't have an issue as to which way you want to go first. If you want to do where you general first, we would be. We did the other way the last time.
No, we took that on first year and then that's all we got.
I don't see what the difference is. I don't know if there's a difference. From my perspective, it's faster than the other. Let's just do that.
Thank you. I will say that I think the state's being rather optimistic that we would start general law diet
That's March.
the week of the 23rd. I think that's very optimistic, and I hope they're right on this.
So what holidays you agree that you want to be off of? Which ones are court closed?
So I am unavailable from October 27th through October 1st.
Why is that?
I recently planned to predate this, that was both February 14th of this year on that one.
I'm sorry, February,
Booked in
October
February
27th.
That's
a Friday.
27th
That's a Friday, right?
through the 31st.
So Monday, Tuesday.
Yes.
So, is there any issue with that, please?
No.
So, what other days?
So then November 1st and 2nd are good. So then the following week, the courthouse is closed on the 10th.
Yeah.
So we're not in session on the 10th, but that's a Friday. So what are the days that the courthouse holiday?
And so then the courthouse holidays are November 23rd and 24th for Thanksgiving. Miss Liberty suggested because Broward County schools are closed that entire week.
Is that Miss Liberty or Miss Bradley?
That was Miss Liberty. I said I was good to go those 3 days, Judge.
The moms, and no disrespect intended.
Well, I was just thinking we're going to have jurors that are moms and the schools are out on Friday.
Pardon? What is it? Everybody agree?
Yes.
All right, so that's the 20th, 21st, and 22nd,
So I think
the whole week, right?
The whole
the
week.
20th through the
Well, the
24th.
23rd, 24th, courthouse closed anyway.
Correct.
That whole week.
The whole week is off. And both sides agree.
Yes.
So then, if we're doing, I don't know if it'll be a testimony at that point or not, but then we're coming back the week of November 27th through November 27th through the 30th. No issues or anything on that. December 4th through the 7th, there's no issues, but the only possible exception of some jurors may be us to end earlier as Hanukkah starts December 7th and continues through December.
Whatever holidays are on, we just, somebody says they need a holiday.
I would be asking to leave a little early.
It's fine. It's not an issue. All right?
Like at 10 o'clock in the
You just
morning.
got to remind them.
Well, what is
It's not an issue. All right, whatever because jurors sometimes may feel that, they're reluctant to raise their hand, but they want to be out of here because of the holiday. It's not an issue. You just tell me when it is for the holiday.
So that would be, I'm just trying to keep count on running days, so if we're assuming we've got a jury by the beginning of then that would be on, potentially being on May 16, trial, which is what it took us last time, to try the case. Most of the would be through December 7th. Then if defense is putting on a case, we're looking at potentially the week of the 11th through the 14th. And then we're getting very close to the Christmas holiday, which I don't think is fair to ask anyone to be sequestered over that time period. And I think
We have some moms here too.
yes, and so
What
there's,
days you want to be off instead?
that would be 2 weeks because of the way the school is set. And from December 25th through January 5th, there's no,
Agree.
You agree?
Yes.
Whatever you guys agree to, it's fine with me. So what's that date? What date are you saying it's going to be off over Christmas?
December 25th.
Right, you said before that, right? So is it that the first day you're going to be off? Is that 25th? All right.
Christmas Eve.
It's Christmas Eve, it's a Sunday.
Oh, it's Sunday.
School gets out on the 22nd at noon, which is a Friday.
So that week, the 25th to the 28th, those 4 days taken off, is that right?
Yes.
All right, hold on, I'm just trying to keep up with you. And then, 29th are Friday, so we would be in session anyway. So then what's going on for January?
January, from here, there's another piece that's set, but it's been fine, so that's still in the trial. Didn't he has told me again.
Well, January 1st is a Monday. No one's going to want to sit.
Well, that's this.
Oh, that 2 weeks.
Yeah.
Oh, I'm sorry.
What 2 weeks, what are you talking about?
We already covered it.
From the 25th
To the 5th.
through...
January 5th?
We already covered it, yeah.
Yes.
So the last trial day before that holiday period would be that past Friday, the 22nd,
No, 21st.
the 21st.
And so that's what I was gonna ask, are there, the bill any time for the motions, the depositions that need to happen, because I was telling defense counsel, the only
Yeah, Friday.
everything's scheduled. So the only Friday that I currently have available is October 13th. Between now and then, going until December 1st, and then the next one over.
December 1st?
December 1st, yes.
Again, it's co-counsel here, and we would attempt to accommodate them, but that, wait, that period of time.
We're in trial. This is going to be a trial, so either work around it, get somebody to cover. If you can't be here and you want somebody else to cover, get somebody to cover, or if you want have somebody cover whatever else you have there, or reschedule it, that's fine. But this needs to
So the only thing that I would have to be there for specifically would be October 20th. That's a sentencing hearing on my last trial I would finish this week.
What time of day is it?
That one is at the final review of land.
Can you get it, move it up?
It's a PSI that has to be brought back on it before sentencing. So, in terms of time frame, get another sentencing as well as in.
I'm talking about it on the 20th in the 9 a.m.
I can ask. I don't know if it's defense counsel that was unavailable in the morning or what, so why you pay that time.
What's the defense name?
That'd be Sanjay Johnson,
S-A-N-J-E.
S-A-N-J-A-Y Johnson,
My bank's good.
Bank 17753 Sanjay.
So it's on the 20th. See if you can move it here. Is it 10 o'clock? Oh, there's still. Oh, so you can do the available for an hour. So maybe I see if I can get it moved up a little bit. I'll ask him. So what else you got?
One housekeeping issue, Judge. Trivia on the last week, Bobby testified in the last trial, started testifying because he drove down to Vero and stayed in a hotel and had the same extra night he would do on the postman. So my understanding is the lady said she would compensate him either to drive or the hotel where there was some back and forth. He still has not been compensated. So I just need to know what the council is doing regarding the compensation.
So, I wasn't actually there, it was Mr. Adelson who said he would pay for the gas mileage from Vero to here. It's a 2.5-hour drive. We didn't ask him to stay in a hotel, we just wanted to depose him. We've got everything but an invoice for the gas. So if I could get a gas bill, we could get the money and we'll pay it. I'm not paying for, I believe we got a hotel room bill for days that we weren't even deposing.
Fair enough. What else you got?
Judge, I just wanted to mention that we were operating, of course, I'm kind of new kid on the block. Operating under your Honor's pretrial order about motions and motions in limine, and that date, cutoff date is 10 days before trial. So we have some motions we've been working on that we're about to file. So there's a 10. So, that pursuant to your order, we followed and we're working on it and we're going to file on grounds and issues that were not raised previously. So I don't know how we're going to end up dealing with those, but I just wanted to throw that in because
That's why I mentioned before that before this trial starts, on the trial, in other cases, the same type of thing. The hung jury, Brad is trying to John Williams after the defense has to go for 2 weeks before, and then the following week, October 3rd, is I have game plan. So I'm trying to get them, but I'll be out of it.
of course we don't want to interfere with this trial's scheduling, but it's a first degree murder case, and
Do the best we can.
that's all. I just wanted to bring it to everybody's attention. I'm not trying to spring anything at the last minute. That's okay.
I'm not trying to bring anything to the last minute, that's why I try to bring it up and let you know what my schedule is.
Understood.
Trying to respond to those
Of course.
motions. So rather than wasting time with the jurors, defense counsel is filing motions very shortly before we're supposed to start trial, perhaps they would be better served by filing those motions, and then as we've all blocked off our calendars for the month of October for this trial, we could then proceed to actually do some of those motions and be able to meaningfully, there's witnesses and things that need to be come in without having any jurors waiting, not having any issues anyone else's schedule.
We'll deal with that once we try. Fair enough.
Best we can, so it is. I agree, we need opportunity to review and prepare for motion that I'm going to use.
Hopefully it'll be quicker than a month.
So,
Well, they're going to be filed, I'm assuming, next week?
So, we're working hard on them. The court's order said 10 days before trial. I think that's coming up pretty soon. If we get them done beforehand, even if it's today or tomorrow, as soon as they're finished, they're going to be filed. So we're not at all being, not diligent. We just, we try to do a lot in a short period.
We needed the POC.
Yeah, that's going to help speed it up because we wanted to address what you had presented at trial first so that we can kind of handle on it. From a standpoint of knowing what you did before.
So, the other thing that I want to talk about just briefly is find out about a larger court. And hopefully that happens at least at the first week or so. Just going through the order, just like help the process go a little faster.
If Mr. Euston, like you're doing his motion last night to do smaller groups, you know, to make it for certain, questioning for only 20 or 25 at some point, that would be mine.
I really
Just a suggestion, and if it's even possible, but I remember back in the day, Judge Lazarus had that foreclosure division, and on the civil side, that courtroom was huge. And we used to be able to fit in under people.
I wouldn't even ask about it if you can, because there's too many problems with it. They did the Cruz case over on the court over that was because of the nature of that case. Different. And, I don't think they're ESO would want to do that. And that was a special case, but walk next door, 2 doors down.
68-4. You can go to any of your courtrooms that are in 40. They're all the same size, guys.
Okay.
It's just your bowl is right here on this floor.
makes no difference.
But I mean, it's bigger, we might, maybe not for your questioning, but at least for the hardships, it might.
Got it. Whatever the court wants to do, there's no question at all.
We can put close to 100.
Let's see what that one.
Fair enough.
Okay?
Nice seeing you.
Thanks, Judge. Thanks for your role.
Have a nice weekend. Mr. Vidal.
Something up there. Hi. This is on the record. It's set next Friday for status conference. I'd like to move to the Friday after, just in case I walk out of trial. Starting Monday, I want to go to California and take my certificate.
This is on Mr. Cortlen Henry.
I'm sorry?
Cortlen Henry.
Yeah.
So he's not here, but you're.
Yeah, just ask for each status conference week.
Any objection?
To
Do that?
I object.
That's fine. Thank you. I'll be back. Thanks a lot. Thanks.
Yes, sir.
We'll do like a calendar, mark it off, so we
Yes, I'll send it to someone out.
make sure I get it. Orders on these things. I know I'll do the things bond, but on the other orders, so. You can take care of yours.
I'll do the one for the DNA, so we gotta put the.
Okay, just share it back to court, make sure both sides look at it. Whatever you want to do that we've done,
Judge, before you leave.
I'll do it.
Thank you, Mel.
We need him for 1 second. 1 second. It was brought to my attention, actually.
Okay, we're back on the record?
Yes.
Be on the record?
The state indicated that the last time when someone recognized Melly, you asked questions in front of the entire group. And it was brought to my attention, and I agree with the state, that if they recognize him for whatever reason, that should be done individually when you make that request. And I think the state,
Take it every time.
Tell Cortlen this case.
because then it just poisons the evidence.
All right.
Just consider it.
No, you have to remind me, I don't really have an objection to it, but I don't believe when we had these people acknowledge the humility of both Bennett, I don't mean to be disrespectful, but when they said they identified who he was or used it, I never asked questions about more than how they know, not what they know, but how do they know something. It's very limited, my question. I didn't ask.
The court may have, but we, both sides would probably want to pursue that issue, and we're reluctant to do it in front of the entire group.
And so actually, Your Honor, could ask very limited questions. If some of the jurors would volunteer statements like,
Correct.
knowing his music and the titles and the lyrics, I couldn't ever presume him innocent. And so that was the concern of the issue.
Okay.
Thank you.
Just remind me.
Yes, sir.
Thank you. Court's adjourned.
Thank you. Nice seeing you.
Marty Rask.
Are you leaving
I see you. You're like part of the family.
Nice to see you.